I wanted to include 5 reasons why we shouldn't, or why to avoid probate, I guess I should say. The number one thing is that it's time consuming. With a probate, you're in the court, at least in Washington state, you're in the case for between 6 to 12 months on average. Creditors have a 4-month window to make a claim. Add a couple months on the front and the back of that for the most simple of estates, and you're at 6 months. And oftentimes, when it takes so long, assets are tied up because we can't make distributions without paying creditors and without dealing with potential issues the court has. So avoiding probate often speeds up the estate administration. And we've talked about ways to do that. We'll talk more about those things as well through trusts and transfer and death deeds and community property agreements. We've talked a lot about those.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas are estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to those who need it. So if this is something that interests you, I'd appreciate it if you click that subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's episode topic. Today we're talking about unraveling probate, understanding its role in estate planning, so that you know how probate may fit into your estate plan in order to protect your family's assets and legacies. So on today's show, we're talking about unraveling probate, understanding its role in estate planning. So let's get to it. So if you've listened to this podcast so far, you've heard the word probate mentioned regularly. You've probably heard of probate through friends or family members as well. Many people think that probate is to be avoided at all costs, while some don't think it's that bad of a process at all. Today we're going to discuss probate and 10 roles that it can play with your estate plan. There's situations where probate is advantageous and others where it's something that should be avoided. And it makes sense to weigh those positives and negatives to make sure that you have a plan that makes the most sense for you. We're also going to talk about 5 reasons why we should not do probate, and maybe we'll do a separate episode on that as well. The reason we're talking about probate, though, today, and the roles it plays, is so that you can decide how to best structure your estate. There are 10 roles that a probate can play in an estate plan, and I'm going to go through these 10 roles here. So the first role is asset distribution. So probate is the court proceeding to allow you to administer an estate, just for basics off the top. It facilitates the organized distribution of a deceased person's assets based on the terms of a will, or if there isn't a will, based on the state's laws of intestacy, which is the laws that govern people that don't have wills. The process involves valuing assets, identifying inventory, and making sure that those assets are properly distributed among beneficiaries. Probate helps to provide a clear legal framework for the transfer of property titles from the deceased to their rightful heirs. Number 2 is that probate validates a will. It verifies that the validly executed will of a deceased person is in fact valid by ensuring that it meets the requirements of that jurisdiction. So in Washington, it has to be witnessed and it has to be typically notarized to be effective. The court examines that document to confirm that it was executed properly and the person had sound mind and that there was no undue influence. Validating that will through the probate process establishes a legal foundation for the distribution of assets as per the decedent's wishes. So that's 2. Number 3 is creditor claims. Probate allows for the identification and notification of a deceased person's creditors, giving them an opportunity to file claims in an organized manner. The court oversees and reviews these claims and allows the personal representative or executor to do so as well, to determine their validity and ensuring that they're paid properly. Addressing these claims in a probate prevents disputes and ensures a transparent process for settling outstanding debt. Sometimes probate's a really good idea if there's a lot of debt to deal with, because it provides a platform for the settlement and payment of those debts. Number 4 is to have an executor appointed. The probate process involves having an executor or a personal representative, that's one and the same, appointed to manage the affairs of the estate. That executor is granted legal authority to administer assets, settle debts, make distributions, carry out the people who make the will's wishes. And it also provides a structured framework for an executor to follow. So you're jumping through hoops with the court, but there are specific hoops that are defined, which can help, right? It can help an estate that could be contested, for example. Number 5 is dispute resolution. Probate serves as a forum for resolving disputes among heirs and beneficiaries and creditors and all those things. The court addresses challenges to wills and the validity of that will and disagreements about the will and distribution of assets. All that stuff can be handled within that probate court. And as things get resolved, the integrity of the estate administration process is intact. I'll talk more about that in a bit. Number 6, property title transfer. So the primary reason people file probate is to have their properties transferred, right? Real estate transferred, bank accounts, investment accounts transferred. And the reason why is because they want to make sure that they're transferred the way they're supposed to be, but also they want to make sure that they have the authority to do it. Otherwise, the transfer might not be effective. And so the probate process ensures the legal and valid transfer of title to beneficiaries, or it allows an executor or personal representative to sell property or assets as part of the estate prior to distribution. And the court oversees all of that process. And it basically makes sure that there's clear ownership of who owns this property now that this person has died. So that's important. That's one of the biggest things, is if we've got a client with a piece of real estate or bank accounts that are over $100,000, then the probate process is essential in those situations when there's no other form of transfer that's been set up. Number 7 is taxes. There's a couple different kinds of taxes that we're talking about here. Income taxes and estate taxes. So not everybody has estate taxes. The vast majority of people don't have a taxable estate in the state of Washington. We have an exemption that's just over 2.1 million for everyone that can pass assets for less than that without tax. But if you do a probate, the court allows you to make sure that those taxes are paid properly and that the estate is settled properly in that regard. The income tax side is typically one files a final tax return for a deceased person, and that can be carried out by the personal representative of the estate under a probate. So it just makes it a little bit simpler and cleaner sometimes to have a probate open so that those taxes can be paid in an orderly fashion. Number 8, legal notice. And this is important, right? In a probate setting, the personal representative is required to provide legal notice to creditors and to potential heirs of the estate, beneficiaries of the estate under the will. And it makes sure that it basically puts them on the clock, okay? All interested parties are put on the clock to whether they want to contest this will or the estate. And creditors are put on the clock that says basically, hey, you have 4 months to make a claim in this estate or you're out, okay? So a lot of the time, we'll make sure that we notify creditors in the newspaper. That sort of gets general creditors that we might not know about. But we'll also give exact actual notice to creditors where they have to make a response within 30 days or their claim is not processed. So that's a positive thing for estates that have a lot of debt, a lot of bills to pay, and not a lot of money. Number 9, guardianship of minors. So this is something that we think about if we have minor children and we have a will that says my kids go to Aunt Sally, then that portion of the will is administered through that probate process and basically converted into a guardianship process. So that guardianship can be set up according to your deceased person's wishes. And the court makes sure that happens and that's the right decision in that moment. If nothing has changed that maybe makes Sally no longer a good choice. And so that court probate process ensures that suitable guardianship arrangements are made based on your wishes. Finally, number 10 reason we should do probate, or the role it plays in your estate plan, is accountability. So probate provides a system of oversight to ensure that the executor fills their duties in accordance with the law. The court, when the probate is over, reviews the executor's actions, accounting, and decisions to make sure that those are in line with what the will asked for and in the best interest of the beneficiaries. And basically, this goes back to the integrity of administration. Having accountability basically makes sure that everybody knows everything's above board. There's nothing untoward or illegal or against someone's interest that's happening because of this probate. Okay. Because it's supervised closely by the court, regular reports are given to beneficiaries, accountings, inventory, all of those things. And so it's important and it basically legitimizes the process. So with those 10 things, I wanted to include 5 reasons why we shouldn't, or why to avoid probate, I guess I should say. The number one thing is that it's time consuming. With a probate, you're in the court, at least in Washington state, you're in the case for between 6 to 12 months on average. Creditors have a 4-month window to make a claim. Add a couple months on the front and the back of that for the most simple of estates, and you're at 6 months. And oftentimes when it takes so long, assets are tied up because we can't make distributions without paying creditors and without dealing with potential issues the court has. So avoiding probate often speeds up the estate administration. And we've talked about ways to do that. We'll talk more about those things as well through trusts and transfer and death deeds and community property agreements. We've talked a lot about those. Number 2 is costs and fees. With a probate, you're almost always going to hire a lawyer, and the court also charges fees to file the case. And so you're going to have a higher expense in the administration side if you have probate. So because you're going to have to hire a lawyer typically, it makes it a lot easier to have a lawyer. Coming from someone that is a lawyer that does this for a living, it's a lot easier. But that does leave potentially less for beneficiaries in the long run. Number 3 is lack of privacy. And we've talked about this on previous episodes. No one wants their nosy neighbor showing up over at the probate court to see what assets Johnny had, look at the inventory and the accounting, and basically spreading gossip all around the neighborhood. We don't want that because all those public records at the superior court level are available for anybody to look at. And so a lot of people want to ensure that privacy is taken care of. They want to keep things confidential. And in those cases, you should probably avoid a probate. Number 4, and this is something I always tell people, while probate, we talked about having probate as a venue in one of the reasons to have it, a venue to resolve disputes. A negative about probate is the potential for disputes. And what I tell people typically is, if you think this thing is going to get contested, this estate is going to be contested, there's some things you can do. One of the things is don't provide an automatic venue for the person contesting a will by opening probate. And so I just think a lot of the time, if you don't open probate, it just adds other hurdles to people trying to contest an estate to jump through, basically, to get their complaint heard by the court. It doesn't have an automatic setting in the probate case that's already open. So in those cases, like a revocable trust would be a better choice, typically. And disinheriting language and all that stuff, which we can talk about in future episodes. Number 5 is control over distribution. So with a probate, you're following the will. With a trust, you're following a trust, though, right? But with a probate, you're following a will under the supervision of a court. And as far as like distributions that are based on someone's preference, that may be more advantageous that they have something distributed one way or another, there's much less flexibility with a probate than with a trust per se. And so basically how you want someone to get their part of the estate, their ownership in the estate, their distribution, depending on how you want them to get that, there's better ways to do it than probate in several cases. So that's something to also consider. So I've got a story, as I do for every episode. This one's not a great one. But I had a client many years ago, Larry, and he had a pretty elaborate estate plan. He had a revocable trust as his main document. So you're wondering, why did they have to go through probate? He had a trust. He also had business entities that he was dealing with. He had a small business. And he managed his estate well, but he was struck with cancer late in life. Actually, in the prime of his life, after he'd ever had everything set up, he was struck with cancer. And this was a significant factor in how this story progresses. So when he received this cancer diagnosis, he tried to repair a relationship he had with an estranged daughter, knowing that he was possibly dying soon. And they began to spend time together, and their relationship warmed. But this daughter never lived with Larry's two other children, half siblings, who were from a different marriage, and she was an outsider, and they didn't know her, and she didn't know them. Okay. But because of this change in relationship, Larry amended his trust to provide his daughter with a nominal percentage of the estate. Okay, so he said, I want to give my newfound relationship with my daughter some credence, and I'm going to give her some money. Unfortunately, when Larry died, his son was named successor trustee of his trust, and he realized shortly after Larry died that he had not transferred certain accounts into his trust. So we had to open probate for assets for about $200,000. Everything else was under this trust. We thought this would be simple, right? $200,000 in cash, basically. Let's make this easy. It'll be a quick one, right? But as we've been talking about, his estranged daughter saw this as an opportunity to contest every little thing that the executor did. She requested extensive inventories and accountings beyond what is typically required. She even filed an action within this probate case to contest the way the probate was being administered, to pull assets from the trust and business entities to be included in this estate and have the executor removed. And so in what should have been a simple process to distribute Larry's estate, having a probate simplified the process for his estranged daughter to wreak havoc on his other children and their potentially, or actually they got more, right? Their higher distributions and their better relationship with their dad. So there's a lot of jealousy involved in there. And so what happened really is this probate was open for years, and ultimately it was resolved, but not before multiple court proceedings and disclosures and all this stuff that shouldn't have had to have been done had this been uncontested. So because of that, there was extensive legal fees by the executor, paid by the trust and the estate, but that also increased stress as far as the distribution goes, as you can imagine. So the reason I'm telling you this story is to show you what can go wrong. Even if you have an acceptable estate plan, right? You have a really good estate plan. Larry had a great estate plan. He had a trust, he had wills, he had power of attorney, he had some business entities that protected his assets. But if it's not funded properly, that trust doesn't work completely. And it requires a probate to get those other assets into it for distribution. And that was the problem here. And so if you do have a trust or get a trust like that, make sure that it's funded so you don't have to have the same thing happen that happened to Larry's family, because you never know what's going to happen. I guess there's a couple of things that we learned today. 10 reasons why or how a probate is essential or a good part of an estate plan, and 5 reasons why we shouldn't do it. I think the reason we want to know those things, like I said before, is so that you know how to structure your estate, or at least consider that in determining how you want to structure your estate. And I think we'll all be better off that way. So I want to thank you for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please subscribe for more content like this. And we will talk to you next time. Thank you.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.